Keith, thank you for the introduction. Let me start by also thanking the participants for attending today's Irish Construction Law Conference. I'm a chartered arbitrator and engineer. I'm a professional qualified in 4 distinct engineering disciplines. In the late 1990s, I had a lot of experience providing expert evidence in construction and engineering disputes. I've given evidence in the Technology and Construction Court in London 3 times, and several times in arbitration proceedings. At that time, many experts paid scant attention to the principles set out by Mr. Justice Creswell in the landmark Icarian Reefer case, in which he lists the duties and responsibilities of expert witnesses in civil cases. In about 1997, I was providing expert technical and quantum evidence in a construction and engineering dispute. I attended an 11-week arbitration hearing in Bourneville in England, where the arbitrator sat Monday to Thursday, and on Friday he was working on his notes. I was cross-examined on my expert report for 4.5 days. There were a lot of people in that hearing room. In addition to the arbitrator, both parties had a barrister. There was a part-time senior solicitor, a full-time junior solicitor. There were experts, and of course the parties had senior staff present. Let us pause to think for a minute about the cost of those proceedings, even if just from an arbitrator's perspective. Let us say in today's money the arbitrator was charging £400 per hour, by 50 hours per week, by 11 weeks. That amounts to £220,000 sterling. Barristers charging a similarly hourly rate, plus the cost of solicitors, experts and all the other costs, including loss of profit costs. Of course, in addition to the arbitration hearing costs, there are other costs for the preparation and defence of the claim and the writing of the arbitrator's award. The arbitrator decided that the respondent should pay the claimant more than the respondent's offer, and guided by the costs follow the events principle, the claimant who had instructed me was entitled to recover costs. There was a dispute over costs. The arbitrator did not want to deal with that, and so the cost disputes went to a taxing master at the TCC to assess the claimant's recoverable legal and other costs. As part of that proceeding, I was cross-examined in the TC for half a day about the fees and expenses invoice I had raised. The claimant and their legal team were going out for a dinner in London to celebrate the arbitrator's award, and they invited me to join them. At the dinner, I asked the barrister, there was a dispute, and now we have a dispute over the costs of the dispute. Is it possible to have a dispute over the costs of the cost dispute? He rubbed his hands gleefully and smiled. Of course there is. These were all lovely and very professional people, but I remember at the time thinking, if I was to choose one word to describe this situation, I would choose the word obscene. 6 countries have promulgated adjudication or security of payment legislation. Where it is available, adjudication has all but eradicated arbitration in construction and engineering disputes. The topics that CMG have asked me to cover today are as set out in the programme and as are repeated in this slide. At the Adjudication Society conference in Croke Park on 10th of May 2017, one of the great and the good of the Irish ADR community stated, "I cannot imagine circumstances where I would commence adjudication." I remarked, one of the circumstances which will lead you to adjudication is, if you need the money. The use of adjudication in Ireland is growing. CCAS adjudicate nomination statistics are, in the first report there were 0 nominations, in the second report there were 9 nominations, in the third report there were 32 nominations, in the fourth report there were 46 nominations,
in the fifth report,
a COVID-19 pandemic period there were 37 nominations, and from 26th of July to 15th of November 2021, 13 nominations. The statistics for the most recent period suggest that for the year 26th of July 2021 to 25th July 2022, the CCAS will nominate adjudicators about 50 times. An adjudicator's decision is said to be temporarily binding, but in an April 2020 article posted by Reddy Charlton, that indicates that a great many adjudicators' decisions are the basis of a construction dispute being settled. And why is that? Well, one of the reasons for that is, right from the get-go to today, the benefits of having an adjudication infrastructure have enjoyed judicial recognition. In Balfour Beatty Construction Limited versus the Mayor and Burgesses of the London Borough of Lambeth, His Honour Judge Humphrey Lloyd QC said, "Nevertheless, in my judgment, that which is applicable in arbitration is basically applicable to adjudication. It is now clear that the construction industry regards adjudication not simply as a staging post towards the final resolution of the dispute in arbitration or in litigation, but as having in itself considerable weight and impact that in practice goes beyond the legal requirement that the decision has for the time being to be observed." In John Doyle Construction Limited in liquidation versus Erith Contractors Limited, Lord Justice Colson said, "I rather cavil at the suggestion that construction adjudication is somehow just a part of ADR. In my view, that damns it with faint praise. In reality, it is the only system of compulsory dispute resolution of which I am aware, which requires a decision by a specialist professional within 28 days, backed by a specialist court enforcement scheme, which, subject to jurisdiction and natural justice issues only, provides a judgment within weeks after. It is not an alternative to anything. For most construction disputes, it is the only game in town." Let me succinctly summarise what I consider the adjudicator's role to be. The adjudicator's overriding obligation is to deliver a decision which will withstand judicial scrutiny within the time limit. The Code of Practice governing conduct of adjudications at paragraph 28 sets out that the adjudicator has an obligation to use reasonable endeavours to process the payment dispute between the parties in the shortest time and at the lowest cost. Jurisdiction is an adjudicator's authority to make a decision. Applicable adjudication legislation and the contract between the parties give the adjudicator authority to act. The notice of intention confines the limit of the adjudicator's jurisdiction. If the adjudicator does not have jurisdiction or acts in a way to lose jurisdiction, then a competent court will not enforce any purported adjudicator's decision. There are two types of challenge to jurisdiction. The adjudicator does not have jurisdiction because they lack threshold jurisdiction. The adjudicator acts in a way to forfeit jurisdiction for breach of the principles of natural justice. In adjudication, it is common for the responding party to raise jurisdictional challenges. An obvious reason is that, believing something is inherently wrong, it wishes to avoid the expense and nuisance involved in dealing with adjudication. It wants to stop the adjudication and therefore payment of any decided amount. Jurisdictional challenges are sometimes part of a strategy for dealing with an adverse decision. Casting doubt about jurisdiction introduces an element of risk into enforcement proceedings and makes the enforcement of a decision potentially more consuming of resource. Responding parties can use this predicament to negotiate a settlement agreement, which although not in terms the adjudicator decided, is nonetheless based on the adjudicator's decision. Many referring parties will accept less now than have to go through enforcement proceedings, no matter how streamlined that process is. On the other hand, many parties will look at an adverse decision and conclude that although they could subsequently arbitrate or go through court proceedings, incurring additional expense and energy, the final binding outcome might not be any more advantageous to them. However, as the Honourable Mr. Justice Ramsey wrote in Lynette v. Halliwell's, it is currently a regrettable feature of adjudication that, in many cases, the parties spend a great deal of time and money considering and arguing about jurisdictional matters, with the effect that the adjudicator, either at an early stage or in its decision, also spends much time dealing with the jurisdictional points changed. If I had been giving this presentation in December 20, I would have said that 20 years ago, when adjudication was in its infancy in Northern Ireland, adjudication challenges were commonplace, but now they are rare. But this year, in 21, I have had many adjudication challenges in Northern Ireland disputes. Adjudication challenges in the Republic of Ireland are commonplace. As an adjudicator, when you face your first jurisdictional challenges, it's easy to go, "Oh my God," but after a while you develop a process and the skills to deal with them expeditiously. When I am faced with jurisdictional challenges, I will write to the party along the lines: In respect of jurisdiction, I am mindful of the words of Judge Thornton of the Technology and Construction Court when Christiana and Nielsen Limited versus the Lowry Centre Development Company Limited, he said, "It is clearly prudent, indeed desirable for an adjudicator faced with a jurisdictional challenge, which is not a frivolous one, to investigate his own jurisdiction and to reach his own non-binding conclusion to that challenge. An adjudicator would find it hard to comply with the statutory duty of impartiality if he or she ignored such a challenge. Accordingly, the adjudicator will consider and investigate the challenges to his jurisdiction. Some claims consultants and lawyers are tricky, and whereas they won't overtly challenge the adjudicator's jurisdiction, in the documents they send, there are many challenges disguised or not clearly set out. It is not for the adjudicator to go hunting for adjudication challenges. In April 2020, in a Republic of Ireland dispute, I issued the directions. By the end of tomorrow, I ask the responding party to send me a standalone document which sets out in detail and enumerates the responding party's challenge to the adjudicator's decision. I ask the referring party to make any submissions it wishes to make on the responding party's challenges to the adjudicator's jurisdiction before the end of Tuesday, 7th of April 2020. Before the end of Thursday, 9th of April 2020, I will send the parties my non-binding conclusion on the responding party's challenges to the adjudicator's jurisdiction. The advantage of this proactive approach is that as set out by the Honourable Mr Justice Aikenhead in Allied P&L Limited versus Paradigm Housing Group Limited, the responding party cannot later rely on good grounds that existed, which it knew about or could reasonably have known about. To help investigate jurisdiction, it is sensible to ask each party to make submissions and to have the opportunity to reply to any submissions made by the other party. This often makes it easier for the adjudicator to do their job properly. However, it's not necessary to invite submissions. As set out by the UK Court of Appeal in MX Capital Projects Limited versus Whitefriars City Estates Limited, the decision of an adjudicator as to his jurisdiction is non-binding. It has no legal effect and cannot affect the rights of the parties. Because of that, the rules of natural justice do not apply when an adjudicator is considering jurisdiction. Most of the challenges included in the slides should be self-explanatory, but let me spend some minutes discussing a few of them. Adjudicators regularly face a jurisdictional challenge on the grounds no dispute is crystallised. To avoid incurring costs and time, referring parties should make sure that a dispute is crystallised and is suitable for adjudication. As set out by His Honour Judge Richard Seymour QC in Edmund Nuttall Limited versus R.G. Carter Limited, for a dispute to crystallise, there must have been an opportunity for each of the parties to consider the position adopted by the other and to formulate reasoned arguments. If a claim is ignored, a dispute can also crystallise. My go-to case law when dealing with this jurisdictional challenge is Halkey Shipping Corporation versus Sopak Oils Limited, where the UK Court of Appeal considered inter alia what constituted a dispute for the purposes of arbitration. And the meaning of dispute adopted was, there is a dispute once money is claimed unless and until the defendants admit that the sum is due and payable. Faced with a jurisdictional challenge no dispute is crystallised, the adjudicator can look at the context, what the parties were doing and saying. It is usually straightforward from the chronology of documents exchanged and what they say to conclude whether a dispute had crystallised at a particular date or time. It is hard to prevent a dispute from forming, and the crystallisation argument is almost never successful. The Construction Contracts Act in paragraph 6.5 provides that the referring party shall refer the payment to the dispute to the adjudicator within 7 days, beginning with the day on which the appointment is made, and shall at the same time provide a copy of the referral and all accompanying documents to the person who is party to the construction contract. In respect of the referral to adjudication is not in accordance with the Construction Contracts Act 2013, it never ceases to surprise me that referring parties, and more particularly their professional representatives, fail to reserve the referral in its entirety. On the 7th day, they will make available electronically a document called something like referral submissions. but fail to make available all of the documents they want to rely upon. If the adjudicator is alert, they will expeditiously identify those documents which are missing and deal with this deficiency by a slight adjustment of the adjudication timetable. This becomes more problematic as time moves forward. As an aside, the referring parties should provide a clear index of the documents upon which they rely. It is frustrating where it takes several hours to download the complete referral because there are zip directories within zip directories. All documents should be given a meaningful title. Wherever possible, scanned documents should be avoided and instead sent in Adobe Acrobat format. During the adjudication, it is common that the adjudicator will recall that there is evidence that will help to decide a particular point. But because they cannot undertake a keyword search, locating the evidence is problematic. In some adjudications, I have had 7 challenges to my jurisdiction. In Northern Ireland, the menu of jurisdictional challenges is longer than the menu of jurisdictional challenges in the Republic of Ireland and includes challenges such as adjudicator has been appointed using the wrong procedure, more than one payment dispute, several independent payment disputes, and trivial matters such as no jurisdiction to decide the A and B appointments fee. One of the lauded benefits of adjudication is that the resolution of disputes on a contemporaneous basis is more cost effective than trying to resolve disputes some considerable time after they arise. Adjudicators have to act impartially, and they should avoid incurring unnecessary expense. With that in mind, and recognising that adjudicators' decisions are widely accepted or used to negotiate a settlement, I take a robust approach in deciding if I should write the decision. I will most usually arrive at a non-binding conclusion based on the test, is there an arguable case that I have jurisdiction? Because this is more likely to avoid incurring unnecessary expense than arriving at a non-binding conclusion on jurisdiction based on the test of the balance of probability. In my non-binding conclusion on jurisdiction, I almost always include the number of hours I have spent. I take the view that the party should have full visibility of the sums incurred with challenges to jurisdiction. The notice of intention in Ireland is analogous to the notice of adjudication in the UK. The notice is the foundation for the scope of jurisdiction of the adjudicator. Because the adjudicator can only decide matters set out in the notice, it's an important document. The referral document must confine itself to the issues set out in the notice, and therefore the notice bounds the content of the referral. The Construction Contracts Adjudication Service provides some adjudication template forms, such as the CCAS Form Number 4, Notice of Intention to Refer a Payment Dispute for Adjudication. The forms are for guidance only. They do not have any legal status under the Construction Contracts Act 2013 or the Code of Practice. When you use CCAS Form Number 4, I recommend that as part of the Notice of Intention, you consider referring to and including a separate and complete document with a more detailed narrative, which clearly sets out the decision that you want the adjudicator to make. Whereas the scheme in the UK requires that the Notice of Adjudication shall set out briefly the nature of the redress which is sought, the Code of Practice in Ireland does not impose a similar requirement on the Notice of Intention. This lacuna can get an unaware responding party into some considerable difficulty. If the referring party fails to set out clearly what it wants the adjudicator to decide, it could deprive the adjudicator of jurisdiction. The corollary is also that it could confer the adjudication with unwanted jurisdiction. In a well-crafted note of intention, what might the nature of the redress sought look like? The referring party asks the adjudicator to decide that the responding party failed to provide a payment claim response, and in accordance with Section 4.3 of the Construction Contracts Act, the referring party is entitled to payment of the amount contained in the payment claim notice. Another, the referring party asks the adjudicator to decide that it is entitled to a 620-day extension of time under the contract or other such time as the adjudicator finds to be due. Another, the referring party asks the adjudicator to decide that it is entitled to loss and/or expense in the sum of $2,836,000, prolongation costs, or other such sum as the adjudicator may decide. The biggest evil that I have encountered in adjudication in the Republic of Ireland is to do with the widespread use of trading names. In 2019, in two linked and parallel CCAS adjudications, the referring party failed to properly identify who it had contracted with in the adjudication documents. When it received two adverse decisions, the responding party said, "Not me, Governor," and metaphorically speaking, put up two fingers. So, make sure you have correctly and completely identified the corporate entity you have contracted with, especially when you encounter trading names. Consistent with the adjudicator's obligation to use reasonable endeavours and to process the payment dispute between the parties in the shortest time and at the lowest cost, most adjudicators' decisions are made without meeting the parties. Twice this year I have come across situations where, in outline, the sums in dispute were around €50,000 with conflicts of both factual and expert evidence. The responding party was adamant that there should be a 2-day oral hearing, one for witnesses of fact and the other for expert witnesses. The costs for a 2-day oral hearing are: adjudicator 16 hours by €300 equals €4,800, expert witnesses 32 hours by €250 equals €8,000. You have the cost of lawyers, you have the cost of the party's time. One could estimate the cost at euros 30,400. Irrespective of the amount in dispute, if both parties want to have a meeting, I will accommodate the request, even if the meeting costs will be large compared to the amount in dispute. If only one party wants to have a meeting, I will accommodate its request only if a meeting will assist me. Whereas most adjudication is on a documents-only basis, there are times when the adjudicator or the parties want to have a meeting. Although the code refers to both meeting jointly with the parties and holding an oral hearing, in adjudication I use the term meeting rather than hearing. In legal terminology, a hearing is a legal proceeding where a disputed fact or issue of law is tried and evidence is presented to help determine an issue. The term meeting connotes a less formal, less adversarial proceeding with more relaxed standards of evidence and process. Any meeting should have a specific purpose. It is for the adjudicator to decide the questions the adjudicator wishes to ask or the issues the adjudicator wishes to address, and to set the agenda for the meeting. In the UK, the Construction Industry Council is an umbrella body representing the built environment professions and acting as an interface with the UK government. In August 2020, I completed a second 3-year term as chair of the CIC Alternative Dispute Resolution Management Board. The CIC is an adjudicator and nominating body, and the ADR Management Board acts as the reference point within the CIC for all issues and matters related to adjudication and mediation that affect CIC members. Achievements include the publication of the CIC Low Value Disputes Model Adjudication Procedure, the CIC Model Mediation Agreement and Procedure, the CIC User's Guide to Adjudication Ireland, the CIC User's Guide to Adjudication UK, and the CIC Adjudicator Complaints Procedure. In response to growing concerns in the UK about the increasing complexity and prohibitive costs of adjudication, where many smaller businesses have become disillusioned with adjudication, in May 2020 the CIC published its low value disputes model adjudication procedure. The main benefit of the CIC LVD map is to give predictability to the parties as to what the adjudicator's fees and expenses will be. Under the CIC LVD map, where the claim value is £10,000 or less, the adjudicator's fees will be capped at £2,000. Where the claim value is £50,000 or less, the adjudicator's fees will be capped at £6,000. Where the amount in dispute is over £50,000, the parties can still elect to use the CIC LVD map, but negotiate the adjudicator's fees. The CIC LVD map has been embraced by 10 of the UK's major adjudicating nominating bodies, who maintain a panel of qualified adjudicator for low-value disputes. A CIC LVD map adjudicator will sit on one of the panels of qualified adjudicators. As stated earlier, one of the benefits of adjudication is that the construction industry regards adjudication not simply as a staging post towards the final resolution of the dispute in arbitration or litigation, but as having in itself considerable weight and import that in practice goes beyond the legal requirement that the decision has for the time being to be observed. For that to happen, the adjudicator must fully engage with the party submissions. The losing party might be very unhappy with an adverse decision, but they should never be able to reasonably say, the adjudicator ignored or misunderstood our position. Accordingly, the amount of time the adjudicator spends should be linked to the complexity and depth of the party submissions. To fully engage with the party submissions can take some considerable work. Earlier I mentioned a 2021 dispute where the referring party asked me to decide it was entitled to a 620-day extension in time and £2,836,000 prolongation costs. As adjudicator, I commended an alternative programme to the parties for the adjudication based on a decision to be made within 42 days, which the referring party accepted. I decided that the responding party shall pay the referring party the sum of £2,585,000 plus VAT. In that adjudication, my decision ran to 99 pages and I spent 98.5 hours. The responding party refused to comply with the adjudicator's decision until a few days before the enforcement hearing in the TCC, but then it did pay the amount decided. On 2 occasions in adjudication in Ireland, one of the parties has asked for procedural guidance, and I have dealt with that by referring them to the CIC User's Guide to Adjudication Ireland. In November 2016, the CIC published an adjudicator complaints procedure. As adjudication grows in the Republic of Ireland, I can imagine that the CCAS will develop its own adjudication complaints procedure. A responding party will say that the adjudicator does not have jurisdiction because the payment claims notice is defective. The requirements for a valid payment claim notice are set out at Section 4.2 of the Construction Contracts Act 2013. Payment notices must be clear and unambiguous. In Henny Investments Inc. versus Beck Interiors Limited, Mr. Justice Aikenhead said, if there are to be potential serious consequences flowing from it being an interim application, it must be clear that is what it purports to be, so that the parties know what to do about it and when. And it must be clear and unambiguous that the application relating to a specific due date is being made. In Caledonian Modular Limited versus Mar City Developments Limited, Mr. Joseph Coulson, as he was then, said, in the UK, the employer's failure to serve a pay less notice within a short period challenging the payee's notice can have draconian consequences. But it seems to me, if contractors want the benefit of these provisions, they are obliged in return to set out their interim payment claims with proper clarity. If the employer is to be put at risk that a failure to serve a pay less notice at the appropriate time during the payment period will render them liable in full for the amount claimed, he must be given a reasonable notice that the payment period has been triggered in the first place. In Severfield UK Limited versus Duro Felguera UK Limited, Mr. Joseph Coulson said, but because of the potentially draconian consequences, the TCC has made it plain that the contractor's original payment notice from which his entitlement springs must be clear and unambiguous. In Jawad Property Investments Limited versus the Interior Group Limited, Mrs. Justice Carr said, whether or not this conclusion can be said to lead to a harsh result for TIG, this is an area where, as the authorities make clear, there is little scope for latitude. If a contractor wishes to have the benefit of the interim payment regime such as that contained in the contract, then its application for interim payment must be in substance, form and intent, an interim application stating the sum considered by the contractor as due at the relevant due date, and it must be free from ambiguity. The valuation here was not such an application. In Syrian Sussex Healthcare NH Trust versus Logan Construction South East Limited, Mr. Alexander Nielsen QC, sitting as a Deputy High Court Judge, said, the principles identified in these 3 cases are not in dispute. There is a high threshold to be met by any contractor who seeks to take advantage of these provisions, whereby a sum automatically becomes payable if a timely employer's notice is not served. The requirements for a valid pay less notice are set out in Section 4.3 of the Construction Contracts Act 2013. On the 15th of July 2021, I wrote to CMG's Training Content Manager, Ms. Sarah O'Toole, with the suggestion that today's conference might include the topic adjudication or their consequences for not issuing a pay less notice. When I did that, I had no idea that Mr. Justice Garrett Simons would consider that topic in two High Court judgments. Acon Construction Services Limited versus Pure Fit Out Associated Limited, delivered on the 13th of September 21. Acon Construction Services Limited versus Pure Fit Out Associated Limited, delivered on the 6th of October 2021. These proceedings arose because Acon Construction Services Limited sought to enforce a decision made by an adjudicator pursuant to the Construction Contracts Act 2013. I was the adjudicator who made the adjudicator's decision. In my 25th of June 2021 adjudicator's decision, I decided that Pure Fit Out Associated Limited's failure to deliver a response to the payment claim notice made by Acon Construction Services Limited had the legal consequence that Pure Fit Out Associated Limited was required to discharge same. One of the reasons why Pure Fit Out Associated Limited resisted the application for leave to execute was that I had breached the principles of natural justice by failing to consider Pure Fit Out Associates Limited defence by not carrying out a true valuation of the works. At paragraph 51 of his 13th September 21 judgment, Mr. Justice Simons emphasised that the court was not concerned on this application for leave to enforce with the question of whether my interpretation of the legal position is correct. The court was concerned only with the narrow issue of whether the alleged failure on the part of the adjudicator to embark upon a true valuation of the works represented a breach of fair procedures. Whereas the High Court has not decided whether my interpretation of the legal position is correct. One summary of Mr. Justice Simons' 13th of September 2021 judgment is that it confirms that where an adjudicator acts within their jurisdiction, an adjudicator's decision which decides that in the absence of a valid pay less notice, the sum claimed in the payment claim notice is due will be enforced. I received a copy of the 13th September 21 judgment the day before it was published on the High Court website on Tuesday 14th September 21. I was kind of excited to see how that judgment sat with the ADR community. One of the first responses via LinkedIn was from James Golden, director at Quig Golden, who wrote in his loquacious style, "So, the CCA does mean smash and grab in Ireland. Smash and grab is always an emotive term. What the judgment means is that if an adjudicator decides that you properly applied for your money and the payer did not properly notify you that it didn't agree, then you're entitled to the full claim you applied for. Lessons there for claimants for sure, but huge lessons for payers." At paragraph 64 of his 13th September judgment, Mr. Justice Simons transcribes part of the adjudicator's decision. And it is that part of the adjudicator's decision which I enclose in the current slides and which I want to quickly review. Paragraph 610. In May 2010, Senator Fergal Quinn introduced the Construction Contracts Bill in the Seanad Éireann as a private member's bill. The stated aims of the legislation were to set up a statutory basis, a requirement for minimum contract terms and review procedures to be included in construction contracts. 1. To ensure prompt flow, ensuring efficiency, amount and timing of payment, and 2. To allow swift resolution of disputes by way of adjudication, allowing projects to be completed without wasting time and money in litigation. At paragraph 612 I wrote, on 19th of May 2010, during the second stage debate on the bill, Senator Quinn advised, the main purpose of this bill is to provide for a mechanism whereby prior notice of an intention to withhold sums from payments otherwise due to contractors must be given. Otherwise, payments must be made in full and or the payee may suspend the provision of works and or services under the construction contract until the payment is made by full. The emphasis has been added by me for this presentation. In my view, if there's any ambiguity as to how a particular piece of legislation should be interpreted, it is entirely appropriate to look at the legislative debate that underpins the word used. At paragraph 613 of my decision I wrote, The Construction Contracts Act 2013 came into being to help to stop supply chain abuse. It should be construed so as to give it a sensible meaning and which makes it operative and which does not defeat the manifest intentions of the legislation. At paragraph 614 I wrote, the provisions of section 4.3a of the Construction Contracts Act exist so that a contractor or subcontractor will know what sum it is due to be paid in a timely manner and the reasons why the amount claimed will not be paid if that is the case. Therefore, it is obvious that there should be consequences if the responding party failed to comply with the provisions of section 4.3a. At paragraph 615 of my decision I wrote, as set out at paragraph 5.1 above, the responding party has referred extensively to UK case law, which cites the draconian and harsh consequences that can accrue from the responding party failing to serve a response to the payment claim notice, a pay less notice. The consequence is that the responding party is required to pay the sum claimed in the referring party's 25th of November 2020 payment claim as notice number 6. At paragraph 616 I wrote, it was always open to the responding party to issue a timely pay less notice, advancing any of the arguments it is cited in this adjudication. It simply failed to do so. It is not for the adjudicator to rescue the responding party from not complying with the subcontract or the law. At paragraph 617, accordingly, the adjudicator decides that the responding party shall pay the referring party the adjusted amount claimed in the referral, which is Euros 242,225.09. At paragraph 618, I wrote, the Code of Practice governing conduct of adjudications at paragraph 28 sets out that the adjudicator has an obligation to use reasonable endeavours to process the payment dispute between the parties in the shortest time and at the lowest cost. In light of the decision set out at paragraphs 5.86 and 6.17 above, the adjudicator has not considered the true value of the referring party's 25th of November 2020 payment claim notice number 6. To me, this seems just to be common sense. If an adjudicator decides that a particular claim is not a variation, say because it is in the contract scope, they would not then go on to value the work undertaken. Having decided that in the absence of a pay less notice, Pure Fit Out Associated Limited should pay Acorn Construction Services Limited the adjusted amount claimed in the referral, the €242,225, it would have been a waste of Pure Fit Out Associates' money to determine the true value of the claim. At paragraph 621, I wrote, S&T UK Limited versus Grove Developments Limited is authority for the proposition that the responding party, having failed to serve a response to the payment claim notice, pay less notice, is nevertheless entitled to adjudicate to determine the true value of an application. However, before the responding party is able to commence such an adjudication, it must comply with the adjudicator's decision in this adjudication. In my 25th of June 2021 adjudicator's decision, I did not decide that before the responding party is able to commence a true valuation of the work's adjudication, it must comply with the adjudicator's decision that I was making. One obvious reason for this is that the notice of intention did not confer on me jurisdiction to make such a decision. At paragraph 64 of his 13th of December 2021 judgment, Mr. Justice Simons confirms the importance of this. An objection that an adjudicator's decision has exceeded the scope of the referral can also be analysed in terms of firm procedures. The party against whom a decision is sought by way of adjudication must be afforded a right of defence. The court should be careful to ensure, therefore, that the adjudicator has not purported to decide issues in respect of which the responding party has not been put on notice. I have had feedback about my 15th of June 2021 adjudicator's decision, in that there are people who do not agree. But no one who does not agree has offered any reasonable alternative to what is the impact of Section 4 of the Construction Contracts Act 2013. They simply bleat that my decision was inherently unfair and that there should be no adverse consequences for them for not complying with the law. I do know that Mr Justice Simon's 13th of September 21 judgment has resulted in a flurry of emails from commercial directors emphasising the importance to their QS teams of responding to payment claims notices with alacrity. Mr Justice Simon's 13th of September 2021 judgment is considered to be an essential and welcome signal to many contractors and subcontractors from a cash flow perspective and payment perspective. I can say with complete certainty that Mr Justice Simon's 13th of September 2021 judgment has improved the payment practices in the Irish construction industry. One of the main benefits of an adjudicator's decision is that it can change the balance of power as between the disputing parties. An abusive or recalcitrant payer quickly runs out of space to turn their backs on their payment obligations. In accordance with the adjudicator's decision, the money decided should flow from one party to the other. In adjudication practice and procedure, I set out the psychology behind this power dynamic. In Ellis Mechanical Services Limited versus Waits Construction Limited, Lord Denning said, where the employer or main contractor can simply say, well, I don't accept your account, therefore there is a dispute, and the dispute must be referred to arbitration, which is ordinarily long and tedious, then the subcontractor is put into considerable difficulties. He is deprived of his commercial lifeblood. In the majority of cases, because one party or the other cannot wait any longer for the money, there's some kind of compromise, very often not based on the justice of the case, but on the financial situation of one of the parties. I come now to by far and away the most important slide in my presentation, and it is to do with the responsibility CCAS adjudicators have to help maintain good order in the adjudication regime. In Mr Justice Simon's 6th of October 21 judgment, he refers to a second adjudicator's decision where the second adjudicator has valued the works in dispute at a figure less than that specified in the payment claim notice and has determined that the net balance payable to the applicant is Euros 94,789 exclusive of VAT. Pure Fit Out Associates Limited submitted that it should not be required to pay the sum of €257,165 exclusive of VAT pursuant to the first adjudicator's decision in circumstances where it has since been decided in the second adjudication that the actual balance outstanding is far less. At paragraph 43 of his 6th of October 21 judgment, Mr Justice Simon says, for the reasons set out in the principal judgment and the within judgment, the applicant is hereby granted leave pursuant to section 611 of the Construction Contracts Act 2013 and order 56B of the rules of the Superior Court to enforce the adjudicator's decision of 25th of June 2021. Judgment will be entered against the respondent in the sum of €257,165 exclusive of VAT. I understand that the second adjudicator's decision was made by a highly respected quantity surveyor, and I emphasise that the comments I make are not a criticism of him. I emphasise that the comments that I make are not a criticism of him. For one thing, I have not seen the submissions that were made in the second adjudication. But it is possible that the amount Euros 94,789 exclusive of VAT decided by the second adjudicator is too high or too low. However, where a responding party in the second adjudication, the referring party in the first adjudication says, Mr. Lawless, you do not have jurisdiction to carry out a true valuation in this second adjudication because the responding party in the first adjudication has not complied with the adjudicator's decision. I am going to give that some serious consideration and will probably not proceed to undertake a true valuation on the second adjudication until the sum in the first adjudication has been paid. Simply put, adjudicators should not participate in adjudications which assist a losing party in circumventing the law, a High Court judgment, and which will undermine the adjudication on infrastructure. To do otherwise keeps the burden of compromise in a negotiated settlement with the referring party, when the first adjudicator's decision passed the burden to the responding party. All CCAS adjudication panel adjudicators should give this proposition some serious thought. In the UK, in the recent case Downs Road Development Limited versus Laxmanby Construction UK Limited, His Honour Judge Stephen Eyre QC considered the novel concept of what payment an employer genuinely considers is due to a contractor when testing the validity of a payment notice. So if you receive a valid payment claim notice, say in the amount €257,000 exclusive of VAT, and your pay less notice proposes the amount to be paid at €1, and the reasons for the difference between the amount in the payment claim notice and the €1 is that it is Tuesday and I am wearing one red sock and one green sock, you can expect to find yourself in difficulty. So, what happens after the adjudicator's decision? Usually the adjudicator's decision will direct that a sum of money to be paid by a certain date. Rather than just wait and see if that happens, on receipt of the adjudicator's decision, it is best practice to write to the paying party, recording receipt of the decision and setting out the paying party's indebtedness. Raise a combined invoice that accords with the sum decided by the adjudicator. For example, adjudication decision of Mr. Niall Lawless dated 25th of June 2021. In accordance with the adjudication decision of Mr. Niall Lawless, 25th of June 2021, referring party invoices responding party, instant the sum decided, plus VAT. Ensure that the precise date the invoice is due for payment is highlighted. This will normally be the date decided by the adjudicator. If you send a consolidated invoice for payment of the sums decided plus interest due to be paid by the date the adjudicator decided, then the paying party cannot argue that it does not have the documentation it requires. It clearly knows what you expect from it. Whereas most parties take an adverse adjudication decision in their stride, comply with its terms and move on, some parties do not. This can be a time of mixed emotions where there is some relief that the adjudicator has directed a payment to be made, but you can be apprehensive that the payment might not happen. Your situation is different if there has been or has not been jurisdiction or natural justice challenges. The paying party may say that the adjudicator was wrong, but in the absence of challenges, it is difficult for the paying party to contest that it should not comply with the adjudicator's decision forthwith. Albeit the paying party has arbitration or litigation options it can invoke later. What happens next often depends on the parties' relationships. If it is an ongoing relationship that you want to preserve, it may be that a meeting will serve the parties best. At that meeting, the parties can succinctly express their views about what the adjudicator got right and what the adjudicator got wrong. Outcomes from such a meeting are that the paying party forgoes arbitration or litigation, but pays less than the adjudicator decided. The paying party is giving more time to comply with the adjudicator's decision, or there's an agreement that the paying party makes instalments. Another outcome could be that the parties agree to alter the way that they work to avoid a repetition of the dispute. If you have not received payment by the date the adjudicator has decided, then you should send another letter giving clear warning of your intention to commence court proceedings without further notice for the summary enforcement of the adjudicator's decision. Unfortunately, this would lead to an additional instruction and to additional costs. But where you are successful, costs spent in enforcement proceedings will usually be recoverable. This fact puts pressure on the losing party. Many losing parties capitulate just a few days before the hearing scheduled in the High Court. On 26th of April 21, Mary Irvine, President of the High Court, issued Practice Direction 105 regarding the enforcement of construction adjudication decisions. From Mr. Justice Garrett Simon's 13th September and 6th of October 21 judgments, we now know that there is a careful and wise man waiting to meet you. Thank you for listening today.